making and advocacy with the government, providing a linkage between trade, the corporate sector, and the government. And in addition to this, we offer a number of services to member industries that facilitate B2B linkages. We have tried to change and stay relevant to the times and introduce many innovative initiatives such as the Sustainable Chennai Forum, Food for Thought deliberations, Women Business Council, to name a few. Our chamber has been providing arbitration services for resolving commercial disputes and have had our own rules of arbitration for the last 2 decades. When the alternate dispute resolution mechanisms and institutional arbitration gained momentum in recent times, our chamber, who is known for our values and ethos with a reputation built over the years, thought it fit to enhance our arbitration services to members. And after much deliberation in the General Committee and with key members, along with the support and guidance of members of the Legal Committee, we established an exclusive MCCI Arbitration Mediation and Conciliation Center for the benefit of our members in our own premises with state-of-the-art facilities. It is a physical center which is just opposite the MCCI main office, but we also have virtual enabling at the center. While in this complex world, commercial disputes cannot be avoided, Madras Chamber is happy to provide an additional service in resolving them by providing quick, cost-effective, and transparent arbitration, mediation, and conciliation services for the benefits of our members and for those who are willing to avail the services. We have already started, and we have a few corporates who are actively using our facilities. More details on the activities of the center will be shared by my colleague, Mr. Anand Gopalan. I'm happy to inform that today, being the first anniversary of the inauguration of our center, we are privileged to have Honorable Justice Mr. Senthil Ramamurthy with us. He will be addressing us on an important topic, arbitration in construction contracts, claims, and challenges. I would like to add that we have members in our chamber from the infrastructure sector who have been part of the awareness sessions on various topics related to the sector and will find this most interesting and relevant. I would once again like to welcome you, Mr. Ramamurthy. So welcome you and welcome each and every one of you to the first MAMC Day celebrations and for this wonderful talk ahead of us. Thank you.
Thank you, Mr. Srivats. It's indeed my pleasure to just add a few words about MAMC and then introduce our chief guest. As Mr. Srivats said, we did open up a physical center on 25th of January 2021, and following that, we decided that hereafter, going forward, we'll have it as an MAMC day every 25th. When we did come about with the idea of the center and the physical reopening of a physical center, many eyebrows were lifted to see in a pandemic situation that we are opening the center. I'm glad to tell you that over the last 1 year, more than 1,000 arbitrations have happened in this center. And the center has also revamped its rules and has empaneled many young and energetic arbitrators. The center has also been holding webinars on various topics every month. We have had speakers from across the globe addressing on from international arbitration to maritime arbitration to guerrilla tactics in arbitrations, and various interesting and current topics have been addressed by the speakers the last 1 year. The chamber wants to be a center for excellence in arbitration, and as part of it also proposes to hold workshops. For instance, we're next planning to have an award writing workshop and followed by a certification course for arbitrators. The decision to have the MAMC day on 25th, in fact, of January was taken just a few days of a week back, I guess. And we had the pleasure of inviting Justice Senthil Kumar Ramamurthy. As humble as he is always, he readily agreed without making even winking his eyes there, and he said, yes, certainly I will be there. Thank you, Judge, for accepting our invitation and being part of this first anniversary celebrations of MAMC. Justice Sendil Kumar Ramurthy is a law graduate from the Madras Law College. He's also done his master's in international and constitutional law. He is he was an awardee of a research fellowship by the UGC. He started his career with senior advocate Arvind Datar, and thereafter moved to a law firm where he also became a partner. He's one of the few persons, I think, who from a model law firm has been elevated to a judge. I have had the privilege of appearing before him as a judge, not as much I would like to, but the few times that I have appeared, it's always been a pleasure. And now looking forward to hear from him on the topic. Thank you, Judge. Judge, the virtual floor is yours.
Yes, Mr. Anand Gopalan, I've been getting some message asking me to rejoin. Is it fine that I proceed as is? You're able to
Yes.
hear me?
Yes,
Well,
We can hear you, sir.
very well, very well. So at the outset, it's my privilege to address all of you on the first anniversary of the Arbitration Center of the Madras Chamber of Commerce. I think it's an extremely important initiative that you've taken, because one of the central problems ailing arbitration in India is that much of the arbitration continues to be by way of ad hoc arbitration. And, the sooner we make the transition to institutional arbitration on a large scale, the better it is for the arbitration landscape in India. So I would like to, thank the Madras Chamber of Commerce for having taken this initiative. Very good evening to Mr. Srivats Ram, Mr. Anand Gopalan, Mr. Anirudh Krishnan, other organizers of the Madras Chamber of Commerce, and all the attendees at this event. Now, you see, many of you often wonder why it is that courts are reluctant to interfere with the arbitral process. So I'm going to begin with that. You see, when people opt for arbitration through a contractual mechanism, they are agreeing to resolve their disputes through a private consensual forum. So what you do is you're opting out of the public court system. Once you opt out of the public court system, the legislative policy, which is followed globally, is that the public court system would be available to you only in very limited circumstances. This is the underlying legislative policy, which you would find, finds expression in arbitration legislation
Judge, we have lost you.
I suggest that we reach out to him and have him reconnect. This has happened before on WebEx.
I'll just talk to him, sir, again.
The judge is just reconnecting.
We are trying to resolve the issue. He has a bandwidth issue. Just bear with us. Can we continue? Probably, I think. Just
Mamc sir is joined back, sir.
he has issues again.
Am I visible now?
Yes, sir.
Yeah, we can see you and hear you, sir. Go ahead.
Very well. Very well. So I was on, why courts normally don't
So we are able to see you.
process. I
I hear you
was
here.
basically pointing out that the legislative policy is that the public court system will not permit somebody who has opted for a private consensual forum to not.
I think you're still in mute. We are not able to hear you.
Are you able to hear me?
We are able to hear Mr.
Yeah,
Anand.
we're able to hear
Yes,
you.
yes,
Please
sir,
go
we
ahead.
are able to hear you. You can go
Very
on. Yes, sir.
Very well. Therefore, the legislative policy is that you're not permitted to knock on the doors of the public court system, except in certain limited and specified circumstances. So, as a consequence of this, you see that 3 stages in relation to arbitration assume significance. I would say the first stage is the pre-arbitration stage, which is also otherwise referred to as a contract management stage, the arbitration stage itself, and then the stage which comes post-award when you challenge the arbitral award. And out of these 3 stages, I mean, I will be sort of making reference to the pre-arbitration stage as well, but much of my focus is going to be on the arbitration stage and to a lesser degree the post-award stage. Now, from my experience, one can categorize the kinds of arbitrations that at least come up before court into about 4 or 5 types. You have a very large number of cases arising out of loan transactions between lenders, borrowers, and guarantors. Now, these are the simplest forms of arbitrations, and that's partly why I chose to focus on construction contracts, which are another significant category of arbitrations which come up before court. A third category I would say is commercial contracts, which are probably simpler than construction contracts, but a little more complicated than your plain vanilla loan transactions. You also have arbitrations arising out of corporate transactions. They are fewer in number. Again, they would be fairly complex. But for purposes of today's speech, I will largely focus on construction contracts. But many of the concerns that arise in the context of construction contracts would probably also apply to other types of arbitral disputes. Now, coming to construction contracts, most of you will know that there are EPC contracts and there are other types of construction contracts such as concession agreements, which are often awarded on a build, operate, and transfer basis or variations thereof. Now, in EPC construction contracts, again, there are different payment methods. For example, you have fixed price contracts, you have measure and pay contracts, you have cost plus contracts. And each type of contract has its own implications when it comes to disputes. A fairly large proportion of contracts wherein the employer does not have too much sectoral or domain knowledge are likely to be by way of fixed price contracts. The reasons for this are not very far to seek. It's because, let's say you were to hire somebody to build a house for you. Chances are that you will get fooled unless you go for a fixed price contract, because you have no idea of the different materials that go into the construction process, and therefore the contractor concerned could easily pull wool over your eyes if you were to opt for a measure and pay contract. On the other hand, if the employer concerned is, let's say, a large organization with a strong, team of engineers, they are likely to have sufficient domain expertise to go in for a measure and pay kind of contract, which is often also referred to as a bill of quantities based contract. Cost plus is a variant of the fixed price contract. It's not used so often, but on the whole, I would say most construction contracts, EPC contracts, I should say, will either be on a fixed price basis or on a measure and pay basis. Now, if you were to opt for a fixed price contract, one of the concerns that often arises is what is to happen in the event that there is a variation in the price, either of materials or of manpower during the term of the contract. Now, because this problem is typically encountered over the tenure of a contract, parties normally provide for clauses dealing with price variation. And claims relating to price variation are often one of the most commonly encountered forms of claims. The law on the subject is quite clear. If the contract provides for price variation, there's no difficulty. You can make a claim for price variation or escalation. Obviously, if a particular formula is prescribed in the contract, your claim has to be on the basis of the formula prescribed in the contract. It is quite typical for parties to provide for price variation in accordance with, let us say, one of the RBI indices. For instance, the RBI publishes a wholesale price index for all commodities. And this is a fairly commonly used method to determine price variation, both in respect of materials and in respect of manpower. Often, parties rely on indices like the CPI index for industrial workers and the like. Therefore, it is always advisable in these contracts to opt for a price variation clause, which makes specific reference to a particular formula or a particular index. Sometimes the contract is silent with regard to price variation. Now, there are judgments of the Supreme Court in cases such as PM Paul, which was under the Arbitration Act of 1940, where the view has been taken that even if the contract is silent on price variation, nonetheless, you can make a claim for price variation. On the other hand, if the contract prohibits price variation, then a claim for price variation or escalation cannot be made. That is the law which was prevalent even under the 1940 Act in cases like Continental Construction. The law has not changed on the subject. So the contract management team of contractors, or for that matter, even the employer, should be cognizant of the fact that if you negotiate a contract in such manner as to prohibit price variation, it's going to be next to impossible to claim price variation. Nuance on this would be that if the prohibitory clause can be construed as being applicable only during the original term of the contract, you may still have a case to say that you can claim price variation in the extended period, provided the extension is for reasons attributable not to the party making the claim, but to the counterparty to the arbitration. So that is about price variation claims, which are common claims in arbitration. Now, in addition to price variation, you have claims relating to disruption. Now, a disruption claim is commonly referred to as an idling claim in the Indian context. to those of you who are not acquainted with a disruption claim, as the very term disruption indicates, a disruption claim is made because the contract could not be proceeded with during the term of the contract for a specific period. Obviously, if the contractor is making this claim, the contractor should in the first place establish that the disruption is on account of the employer. It is quite common to come across instances where the employer was unable to provide the site and therefore the contractor is unable to proceed with execution of work. Now, on account of such disruption, what would happen is that the contractor would have mobilized both manpower and equipment or materials at the relevant construction site, but is unable to put those resources to use. This is the underlying basis for a disruption claim. One of the problems I have encountered both as lawyer and as judge is that contractors making a disruption claim often make the mistake of adducing evidence not during the disruption period, but during the prolongation period. This happens because there is a lot of confusion about the nature of a disruption claim. As I indicated earlier, a disruption claim is intended to compensate the contractor for the infructuous expenditure incurred during the disruption period. So your evidence should be with regard to expenditure incurred on manpower, equipment, and materials during the period of disruption. And this is an aspect, the contract management team should be cognizant of. The lawyers conducting the arbitration should again be very cognizant that therefore it becomes necessary to adduce evidence of expenditure incurred during the disruption period. And this is a type of claim that can clearly be proved through actual concrete evidence. Therefore, it is not open to the claimant contractor to contend that, this claim should be allowed on the basis of any formula or on the basis of some kind of rough and ready method. And again, I go back to my opening caveat that unlike, any action in a public court system, because in an arbitral process, the scope for interference, the scope for rectification of errors is very limited. Unless you properly adduce evidence of the expenditure incurred on disruption during the arbitral process, it becomes impossible to remedy this by way of additional evidence at the Section 34 or Section 37 stage. So that is with regard to disruption claims. Another form of claim which is very common is a prolongation claim. Now again, as the very expression or term indicates, a prolongation claim is a claim made with regard to the extended period of the contract. Every contractor enters into a contract on the assumption that the resources would be deployed for a defined period, which is the term of the contract. Therefore, if instead of a contract being executed over, say, a 5-year term, it is executed over a 10-year term, the contractor is constrained to deploy additional resources or the same resources over an extended period. This is the underlying basis for a prolongation claim. Therefore, in contrast to a disruption claim, when you make a prolongation claim, the expenditure should be expenditure incurred in the extended period and not during the original term of the contract. This obviously applies both to expenditure on manpower and expenditure on equipment or on materials. One mistake I have often encountered while dealing with Section 34 or Section 37 petitions is that parties tend to rely on formulae like the Hudson's formula, the Illegality formula, or the Emden formula to make a claim for prolongation. Now, this is a complete misconception. These formulae can be relied upon for only one element of a prolongation claim. You see, if one were to break down a prolongation claim, the prolongation claim will consist typically in construction contracts of a claim towards site-related expenditure. Then there will be off-site project-specific expenditure, and you have head office expenditure. Now, out of these three components, if you look at site office expenditure, a contractor is in a position to adduce evidence of site office expenditure on actual basis, be it expenditure incurred on manpower, be it expenditure incurred on equipment. Therefore, in arbitral proceedings, the contractor is under an obligation to adduce evidence of actual expenditure incurred on site-related expenditure. You cannot rely on any formula to sustain your claim. And even if an arbitral tribunal were to sustain your claim on that basis, there's every likelihood of interference at the Section 34 or Section 37 stage on the basis that the award on this claim is based on no evidence. Similarly, the next component, which is off-site but project-specific expenditure. For example, let's say you've taken bank guarantees in relation to this particular project, and because the contract could not be completed within the scheduled period, you are constrained as a contractor to extend the term of the bank guarantees, letters of credit, whatever it may be. Obviously, it entails expenditure by way of, bank guarantee commission and so on and so forth. Once again, this type of expenditure is project specific. Therefore, it has to be proved through hard evidence during the arbitral process. Only the third element, which is the head office expenditure. The head office expenditure, let us say you're dealing with a large construction company. Obviously, that construction company executes multiple projects, including during the course of the same financial year. And therefore, what happens is that the head office expenditure is required to be apportioned across all the projects. Now, it is only for the limited purpose of apportioning that the different formulae that have been recognized internationally, like I mentioned, your Hudson's formula, Illegality formula, Emden formula, and the like, can be relied upon in course of arbitral proceedings. Often parties make the mistake of building the entire prolongation claim on these formulae. And if you do so, clearly the award becomes vulnerable to challenge. So with that, I will conclude what I have to say about prolongation claims. A third form of claim which one often encounters is a claim towards loss of profits. Often such claims are made when the relevant contract is terminated. From the perspective of the contractor typically argues that I would have earned a profit of, say, 10% or 15% if the contract had run its course. Instead, on account of termination by the employer, I have, lost out on that profit. So claims are made. Once again, it is quite common to encounter that these claims are made without adducing any evidence. A claim for loss of profit, I would say, is a little different from any other type of claim, in as much as this claim is made on the basis that if I had executed this contract as per the original terms, I could have earned a profit of 10% or 15%. Therefore, pay me that 10% or 15% as the case may be by way of loss of profit. Given the very intrinsic nature of the claim, it cannot be proved by hard evidence of actual loss of profit. To that extent, one can sort of distinguish it from the disruption claim or prolongation claim that I discussed earlier. Nonetheless, the claimant has to keep in mind that some form of evidence may be necessary even with regard to a loss of profit claim. The two forms of evidence that I can indicate are when you submitted your tender or bid for the contract. You do so by assuming a certain profit percentage. So if you are making a loss of profit claim, that could be a form of evidence that could be adduced in arbitral proceedings. The other form of evidence that could be adduced would be if you have executed projects which are substantially similar in nature. And in those projects, you have earned a profit of, say, 10% or 15%, as the case may be. Evidence of such substantially similar projects could be used in these proceedings to make a loss of profit claim. Instead, I have come across numerous instances of parties making loss of profit claims arbitrarily at 10%, 15%, and the like. No doubt, there are judgments in cases such as Bridgepal Singh, where the court has awarded loss of profit at a fixed percentage. But even those cases are not authoritative pronouncements on the subjects. Often these judgments are distinguishable among facts. There was some evidence even in those cases with regard to similar contracts in adjacent locations and so on. Therefore, it would be a very risky approach to make a loss of profit claim on arbitrary basis. Now, having dealt with these types of claims, I should also very briefly touch on the most basic types of claims, which are claims for payments due towards work done, either non-payment of running account bills or non-payment of the final bill. Obviously, these claims are simple to establish. You will have to prove that you completed the work. You'll have to obviously, produce the running account bills or the final bill. Typically, there would be a completion certificate, and you would be required to adduce evidence of that. An offshoot of claims with regard to work done is claims for additional work. Now, with regard to additional work, often the problem encountered by the contractor would be that the employer may not have approved either the very undertaking of the additional work or the rates in relation to additional work. These are typically the problems that are encountered. Now, when it comes to the very undertaking of additional work, if there is a dispute relating to it, obviously the contractor would have to place before the arbitral tribunal as much evidence as is available with regard to the actual execution of additional work, and then the correspondence relating to the claims made in relation thereto. Typically, most contracts will provide some mechanism for making a claim for additional work. And if so, obviously, the contractual procedure should be adhered to and evidence of that should be produced. From my experience, a lot of disputes relating to additional work turn on the applicable rates. General principle that would apply would be that if rates are provided for substantially similar work, then the arbitral tribunal is likely to accept the rates for substantially similar work as being extended to the additional work in respect of which the claim is being made. Now, these are some of the commonly encountered claims from a contractor's point of view. From the employer's point of view, the most commonly encountered form of claim is a claim for delay. Now, claims for delay are typically claims for liquidated damages, though not necessarily so. If an employer makes a claim for liquidated damages, from the employer's perspective, it becomes necessary, A, to establish that there was breach of the relevant contract by the contractor, B, to establish that the loss was caused by such breach, C, to establish the factum of loss. These three elements are, mandatory, and there's no escape whether it's a claim for liquidated damages or a claim for unliquidated damages. It is when it comes to the fourth element, which is proof of quantum of loss, that there is a difference between a claim for liquidated damages and a claim for unliquidated damages. In the context of a claim for liquidated damages, the legal position prevailing in India is that you may still need to prove quantum of loss unless you plead that it is impossible or difficult to prove the quantum of loss given the nature of the contract. For instance, let's say it's a large infrastructure project executed by the government or one of its agencies. It may be possible for the employer there to say that, look, the losses that are likely to be incurred as a result of delay in execution by the contractor, these losses are such that, it is impossible for us to, even enumerate the different losses and to put a value to it. Therefore, this is a type of contract where the loss is difficult or impossible to prove. That's the reason why we negotiated and incorporated a liquidated damages clause. If a plea to that effect is made, then chances are that the arbitral tribunal may award liquidated damages at the rate specified, provided again the arbitral tribunal were to conclude that it's a genuine pre-estimate. That is where you may end up encountering contentious issues as to whether it qualifies as liquidated damages or whether it's actually a penalty dressed up as liquidated damages. So there obviously the test to decide whether it's liquidated damages or a penalty is to ask the question whether the amount claimed bears a reasonable correlation to loss. If it bears a reasonable correlation to loss, then it's likely to be construed as liquidated damages as opposed to penalty, irrespective of the nomenclature used by the parties. The nomenclature or label used by the parties is not determinative. That's the law in England. That's the law followed in India as well. And therefore, you see, even as an employer, you will have to at least establish the first three elements that I referred to. And with regard to the fourth element, either you prove the actual loss or you plead that it's difficult or impossible to prove if you want to succeed. Now, with this, I will briefly deal with what happens to challenges to arbitral awards from an evidentiary perspective. Now, most of you know that the grounds for challenge are set out under Section 34. Now, these grounds can be pitted into two broad categories. The first category is matters such as, if the tribunal is not properly constituted, if you are unable to present your case, if the tribunal goes beyond the scope of reference, etc., which one rarely encounters in the context of construction contracts. The other broad category would be cases where the challenge is founded either on public policy or on patent illegality. Now, public policy has been reconstrued narrowly after having been construed broadly in ONGC versus Saw Pipes in the line of cases which followed ONGC versus Saw Pipes. Therefore, the position today is public policy is intended to be narrowly construed even in the context of domestic arbitrations and not only in the context of foreign awards or international commercial arbitrations. Coming to patent illegality as a ground of challenge, in the context of evidence, the scope for challenging an award on the ground of patent illegality is extremely narrow. In Associate Builders, the Supreme Court concluded that one can interfere with an arbitral award as regards evidence on the ground of patent illegality under three circumstances. The award is based on no evidence. The award is based on irrelevant evidence which goes to the root of the matter, or vital evidence is disregarded. So unless you are able to fit your case into one of these three limbs, it becomes next to impossible to successfully assail an award on the ground that the appraisal of evidence by the arbitral tribunal was improper. Now, it is very unlikely that an award is going to be based on no evidence. The only examples I can think of from a construction contract scenario would be a claim for loss of profits or a claim for either prolongation or disruption, which was awarded although the contractor concerned did not adduce any evidence of the expenditure incurred in the disruption period or the prolongation period. Then the employer may be in a position to say the award is based on no evidence. If the contractor had adduced evidence of expenditure during the prolongation period, which I have come across in some cases, for a claim of disruption, it may still be possible to say that the award is based on irrelevant evidence. The arbitral tribunal relies upon evidence of expenditure during prolongation period to award a claim during the idling or disruption period. So in that situation, it may be possible to say that the award is based on irrelevant evidence. Otherwise, much of the time, as a party assailing an award with regard to evidence, you will be arguing that the arbitral tribunal has disregarded vital evidence. So vital evidence is not an expression you will come across in the Indian Evidence Act. In my view, this expression was used primarily to underscore the fact that interference with regard to evidence would be very much the exception rather than the rule. So the party assailing an award on such basis should show that it is not just material evidence which was disregarded, it is vital evidence. So if you were to ask me what is meant by vital evidence, I would say that vital evidence is evidence which, if considered, could probably have resulted in the award being different from what it was. So the evidence should be so important to the case that the verdict would probably have turned on it. It is only that kind of evidence which you can call as vital evidence. Otherwise, you see, especially in the context of construction contract arbitration, each party may have filed, let's say, 500 exhibits. It certainly cannot be said that because 10 exhibits were not adverted to in the award, that the arbitral tribunal has disregarded vital evidence. The burden of proof, in my view, would be much heavier on the person assailing the award. You'll have to effectively establish that the result or verdict would have been different if that piece of evidence had been considered. On this aspect, you should also keep in mind one more factor, which is that under Section 19 of the Arbitration and Conciliation Act, the arbitral tribunal decides on the relevance, admissibility, materiality, and weight of evidence. So if the arbitral tribunal had engaged with the evidence, would you be in a position to contend that vital evidence was disregarded? I suppose it could be a nuanced issue, because let us say the arbitral tribunal has referred to a document which you label as vital, but does not specify any reasons for disregarding that document or for not attaching any materiality or weight to that document. The person assailing the award may have an arguable case to say that vital evidence was disregarded, though there is a reference to that document. On the other hand, if the arbitral tribunal has engaged with the evidence which you describe as vital and assigned reasons for not attaching much materiality or weight to the evidence, I think it would be next to impossible for you to establish that vital evidence was disregarded. And in a situation like that, even if the court does not agree with the reasons ascribed by the arbitral tribunal or with the extent of materiality and weight assigned to that piece of evidence, it may not make out a case for interference in Section 34 proceedings, while the outcome may have been different in appellate proceedings. So this only underscores, why it is absolutely vital for parties to focus on the quality of pleading and the quality of evidence in course of arbitration, and for that matter, even at the pre-arbitral stage, when you manage the contract. So with this, I will, close my presentation. If anybody would like to raise some issues, they're welcome to do so.
Thank you very much, sir, for covering such a wide gamut of issues within such a short time frame with your characteristic brevity. We've greatly benefited from your talk. Your permission, if I may just pose a few questions
Sure.
on some of the topics that you raised. So you mentioned that there is a conceptual difference between disruption claims and prolongation claims.
Yes.
Would it be correct to state that while the nature of the claims are different, they arise out of the same breach or same set of breaches during the contract period where there have been, for instance, where the site has not been handed over or drawings have not been handed over? And if so, would there be an overlap between the two? Would the grant of one preclude?
Material have been mobilized, they are at site for those 6 months. Then you see your claim will be confined to that 6-month period. You are right that therefore there could be an argument on behalf of the employer that at least for the first 6 months of the prolongation period, let us say the prolongation period is 2 years, there could be an argument by the employer that, look, whatever claim you are making for the first 6 months, which coincides with the disruption period, there is an element of duplication. So you may have to deal with that very carefully while you construct the claim to avoid an argument that it's the very same amount that you are claiming.
Thank you, sir.
But I'll tell you something else that will typically happen, which may result in the claims not being a duplication, which is that normally you see the disruption claim is made at the early stages of the contract. So for instance, let's say you would have deployed, let's say a piling rig to undertake, foundation work. It's unlikely that you'll be making a claim towards expenditure incurred on the piling rig at the prolongation claim stage. So I think it's a little unlikely. You just have to make sure that you're not making a duplicate claim.
Thank you, sir. There is a question from Mr. Navneet Dugar. The question is this: for finding out correctness of expenditure, can the arbitrator requisition books of account of the contractor?
See, the arbitrator has tremendous power to decide on the procedure. So definitely the arbitrator can call for the books of account if it's necessary. Obviously, the burden of proof is primarily on the claimant, but nothing prevents the arbitrator from seeking evidence which would assist the arbitrator in adjudicating the dispute. So if the arbitral tribunal feels that the books of account should be placed on record, they can certainly call for it.
Thank you. So, taking this forward,
Yes.
considering the voluminous nature of backup record. So, for instance, for site overheads, to say that a particular employee traveled from place A to place
to adduce evidence to that micro degree in all cases, where every let's say transportation bill is placed on record. But I would say that you should produce as much of the critical evidence as possible, and then back it up with you may have some abstracts, etc., for the less significant evidence, less significant expenditure.
Thank you very much, sir. We've greatly benefited from this session. Now over to Mr. Vaidishwaran for the vote of thanks. Vaidishwaran, sir, I think you're on mute.
Before I formally thank the Honorable Judge, I have one question for him. Anirudh, can I ask the question?
Yes, please.
Certainly.
Yeah, this is in the context of, you covered the segment exhaustively, but this is the context of taxes. We find quite often that there are template contracts which refer to outdated taxes or outdated laws, and tax variation clauses do come up in construction-related arbitration. Your thoughts on that?
Yes, I mean, I think it's a type of claim which I didn't expressly refer to, but as you pointed out, it's quite common to come across claims relating to change in law. So it is advisable for the contract management team to always, negotiate and put in place a clause relating to change in law. And this becomes particularly significant in the context of tax laws for the reason that tax laws, change more often than other laws. So if you don't put in a change in law clause, it causes problem. In fact, my suggestion would always be to draft the change in law clause widely. I don't think it's sufficient to restrict it to legislative changes. It should be drafted in such a way it even covers, circulars, executive orders, anything at all that will impact the cost assumptions on which you entered into the contract. In fact, I've often seen this assumes even greater importance in concession agreements because, they are typically of tenures ranging from 20 to 30 years and they're on often on BOT or such basis. So change in law will have a huge impact on the cost assumptions and would render the project unviable. So definitely it's a type of clause that should be incorporated at the pre-arbitral stage. And I suppose it becomes more contentious if you've not incorporated a clause. You may still be able to argue that, look, these were the laws prevailing when I entered into the contract, and that this change in law had a material adverse impact. I think it's still a claim that you can make, except it becomes more challenging for you to establish your claim.
Thank you. Thank you so much. Friends, all of you would agree that we would have got a better speaker than Justice Senthil Kumar Ramurthy on this topic. And Srivath, just for you to know, the 20th January is not only the part of the journey. The learned judge couldn't have made the subject so simpler. He delved into how construction contracts are structured. One would have probably visualized somebody sitting in a contract department in an organization the way he was going through. I'm sure even a person who does not practice in the arbitration segment or who's not an employee in a construction business would understand the nuance at which Justice Senthil Kumar has explained. It was simply brilliant. And not only that, he took us on to various kinds of disputes that can arise from a contractor's perspective, whether it is a disruption or idling or a prolongation or a loss of profits or an additional work claim various mistakes that typically happen in these kind of claims. What errors that are commonly done from a contractor perspective, or even during arbitration. In fact, we can take lessons from this lecture while we even design the award course. And when we structure the arbitration course, we should keep what Learned Justice said in terms of how what is the role of the arbitrator in appraisal of evidence and the critical evidence that is required for these type of transactions. And he went on into the distinction between penalty and liquidated damages, as well as the final point with